everyone. Thank you so much for joining us. We're going to get started now as we have a lot of great questions for Kush and we want to leave plenty of time for his responses. Before we begin, just a quick housekeeping note that this webinar is being recorded. All participants are currently muted. If questions do come up during the webinar, feel free to drop them into the Q&A box. We'll try to get through as many as we can. We did get a lot of great submissions from you all as you registered. And feel free to follow up afterwards. If we run out of time, we are going to try and send out responses to the questions that get submitted to the Q&A. So we will send those out along with a recording of the webinar, hopefully by early next week. So first, I wanted to introduce Poston Communications for those of you who are new to us. We are a PR and content agency focused on the legal industry. We celebrated our 20th anniversary last year, and we are recognized by Chambers as one of the top 20 litigation PR and crisis firms in the US. My name is Georgie Palm. I'm the director of content, and my team supports law firms and lawyers across the country with their chamber submissions, from simply reviewing the submissions to also and providing comments to also managing the entire process for some firms and for some of the practice areas within those firms. Today, we're excited to welcome Kush Cheema, Chambers' North America Research Director. Kush has been with Chambers since 2015, first starting out as a researcher with the UK and US teams and holding various roles with Chambers. He's currently based in New York, and we're grateful to have him here with us today. Kush, thanks so much for being here.
Yep. It's coming up to 10 years I've been at Chambers in August, which is utterly terrifying. People here might have emailed 10 years ago. So apologies for 10 years of disturbing you.
Well, thank you. And we've received a lot of questions, like I mentioned, from the registrants. We had over 160 people register, so we've got a lot of good questions from all sorts of different angles. What we've tried to do today is we've grouped the similar ones together and then added a few of our own just based on some of the work we've done helping clients with their submissions. So first, we're going to get into the Chambers methodology and process. So the Chamber's website says that rankings of departments or individual lawyers are based on some different criteria. So evident legal ability, recognized client service, caliber of bench, commercial awareness, demonstration of diligence, and cost effectiveness. So Kush, can you tell us a little bit, do the researchers give a score on each of these criteria for separate parts of the submission? And are the comments from referees and other firms' feedback sort of taken into consideration when you're thinking about these different criteria?
Yeah, so in our questioning of law firms, in the interview, it can go in any weird, which wonderful direction, depending on how the client rates their law firm. We ask our clients, our referees, our researchers to essentially cover the technical expertise of the firm and the practice group, their ability to handle matters at the top of that industry, the depth, if that was necessary for the use of that law firm, and then we kind of look at value for money, commerciality, those kinds of esoteric things. When it comes to us, our ranking decisions and our internal kind of deliberations, we have a set of scores for sophistication of work, client response, kind of the tone and the kind of the content of the client response, and then depth of bench. Those were the kind of the three things that law firms told us that they wanted evaluation on. Those scores are relative to that practice area. So what I will do when I'm ranking my private equity submission, take the three firms at the top of the market, say Kirkland, Ropes and Gray, Simpson Thacher. They would effectively set the standard, and we're kind of measuring firms against that, against the firms at the very top of the market, and that's how the scores are derived effectively.
Okay, great. That makes sense. So we're going to get into sort of some of the different rankings. So first, we're going to talk about department rankings. This was actually a question that came from a webinar registrant. So do departments that represent Fortune 500 clients tend to be ranked more highly than those representing smaller or mid-sized clients, assuming that all other factors are sort of equal?
Right, so really, so you might hear this a bit from me today, but say for instance our New York corporate rankings, what we're looking for is, Microsoft is buying Activision. What was the deal that was announced a couple of days ago? I'm just blanking on it. If there's a significant M&A matter in one of our prestige areas, kind of nationwide M&A, California M&A, corporate M&A, what we're looking for is the firms that can jump in and provide the resources for those big Fortune 500 companies when they need it. That differs in white collar, for instance. We will look at firms that represent individual officers and directors of, small companies accused of Medicare fraud, as well as, United Healthcare might be accused of securities fraud. It will, all things being equal, we'll look at the firms in their niches. But for some of those areas where the kind of the quality of the service provided for that jurisdiction, that practice area relies on your ability to represent companies at the top rung in terms of size, in terms of sophistication, then yes, it does play into consideration. That will differ in, Minnesota corporate. The top firms will be representing kind of 3M in they're split into three companies. But then we'll have a lot more kind of mid-market companies that are based there, having most of their legal operations based out of there. So it depends, but in those big areas, New York, white collar, no, not so much. Capital markets, corporate M&A in New York, that's where we're looking for the ability to represent those top companies.
Okay, awesome, excellent. So now we're going to turn to attorney rankings. So we've often heard from senior attorneys who are reluctant to participate in chambers. They might feel like their career already speaks for itself, or that a lower than expected band would maybe undercut their reputation. But then at the same time, we have some lawyers who've never submitted to chambers, but they're actually getting a ranking. So, the questions here would be, how would you approach a seasoned attorney with 25 years of experience who's never participated and is hesitant now, maybe because they're going to receive a lower ranking than they would expect. And then on the other side, what are some of the factors to contribute to a ranking where someone hasn't submitted anything to chambers, but then they're being ranked?
And the government's change in administration recently, there's a lot of US attorneys that are joining private practice law firms for the first time. We might not have heard a lot about them. The first thing I would do is just get in touch. There was a partner at Cravath that we ranked for the first time after we very egregiously missed them off for a number of years. And we saw that on the litigation of the year thing that the American lawyer did, the track record of work that this person has had. If we put them into band 6 or band 5, then my head is going to be on a pike outside their offices. So if you wanted to just speak to me, say that this person, explain the situation to us. We'll have there are plenty of people that over this year, a number of people have been ranked for the first time that came out of DOJ or the OSG last year, and they come in very high. So I look after our Supreme Court coverage. So lots of former Solicitor Generals, when Noel Francisco came out, when or Don Verrilli came out under the Obama administration, straight into star practitioner because we had a bit of history on them, but also their position meant that they joined this kind of very elevated position. If it's, if someone hires Merrick Garland tomorrow, we'll probably put him in kind of eminent practitioner and just work out where we should be putting him. But if you work with us, we'll work with you. Particularly if it's just someone that we've missed for a number of years, just get in touch. Our details are all up on the Chamber's website and based on our practice areas, and we will kind of work out the best way to approach each situation. In terms of people getting ranked without ever submitting, it does happen a lot. I was looking at the new people that are ranked this year. There's a lot of them. A percentage of them, I won't say how much, didn't submit. Basically, when we come to our calls with referees, we're not asking them to take Kirkland. What did this partner at Kirkland do for you in terms of your private equity matter? We'll go up to them and ask them, Kirkland have referred you for their private equity group. What's led you to turn that work to them as opposed to other ones? What do they bring to the table? What do the individuals bring to the table? What were the areas for improvement? And by the way, are you using other panel firms? Who else impressed you? Who are the younger partners that have impressed you recently at Kirkland or at another firm? We typically generate a lot of feedback on people who didn't submit, practice groups and lawyers. particularly, I mean, for the law firms themselves, you might have sent in a submission with four lead partners, and you might look at your rankings tomorrow and see that there's an up and comer that you haven't submitted at all. Our conversations are very broad brush. We ask about kind of everyone that they've worked with, and that typically generates enough feedback, which then we will match up against desk research. You know, we have our own internal tools. We have kind of a we do search across submissions to see who's on opposing the submitting firm on matters. And if we get enough information, we will include them. It sometimes takes a bit longer. It might take a couple of years of us looking in depth if someone's come up that we don't have a solution for. But we don't want to limit Chambers rankings to only those who send in a submission and want to be recognizing kind of the very best of the market. And sometimes they don't submit. So
Yeah. Okay, well, that makes sense. So kind of rounding out this methodology, we did get a lot of questions about DEI, with all that's happening in the US around DEI programs, including legal and political challenges. Many firms are reevaluating how they frame their leadership and initiatives in this space, especially when it comes to awards and rankings. So I think just, there used to be a DEI area in the actual submission form. It's not there anymore, or that sometimes we include that for our clients in sort of like the narrative section. So just curious if Chambers is still evaluating leadership in this area within law firms.
we wouldn't be ranking firms based on the makeup of their department. When we asked for those statistics, it was largely internally in terms of, I put out a commercial litigation table in New York every year. We've done it for 20 years. But if I was able to look at, Davis Polk, Cleary, Paul Weiss, and then boutique firms, get an average of their percentages of, male versus female rankings, and then back at my rankings and see, am I wildly out of sync with the reality of the legal market in that specific area? That's what we were using it for, just to measure our discrepancies and realize. And we do ask our researchers to set aside a set number of calls with female or diverse attorneys or kind of younger attorneys who have a kind of a different perspective on, rather than the 60-year-old who's been doing this for years and years and years, just break open the circle a little bit. So that's what we were using. If we wanted to pay a bit more attention, if six firms average told me that their labor employment groups were 60% female and my rankings were 30%, it means that we're doing, I'm upping the required number of calls with female lawyers in that specific area. In terms of how it's evaluated for us is if the clients come back and tell us. So we do ask them, were you satisfied with the diversity of skills and people that the firm was able to provide you, if that's something that you were looking for in your RFP or your kind of your procurement process. And if we get significant numbers of responses to say that, yes, we're sending our more significant work to this firm because of the diversity of the team, or we're not sending any more work to them because of the diversity of the team, because that's when it forms a part of ranking decisions. And you're correct, we don't ask for that demographic information anymore because they gave me a bit of money and I have access to a brand spanking new database and I can use that information externally. So there were a few times where a law firm would send in, we had like a Survey Monkey link for kind of firm-wide information as well. But some firms sent in two or three, and the two or three of them, and the statistics they provided back were wildly different to each other for the same firm. So it's not as reliable. I understand that, but using things like Vault and use some of the other things that I'm using, it means I can do that without asking the law firm to provide it because you've already provided it elsewhere.
Okay. All right. Well, we're going to move to the actual submission content and strategy. So let's just jump right into attorney bios. I know we get a lot of questions about attorney bios. What role do the individual bios play in determining rankings? I think it kind of can vary. Some people just want to include a hyperlink. Some people maybe want to include something that's different than just the hyperlink. But also, how should firms decide how many and which attorneys to include beyond just simply linking the firm bios?
I'd be happy just to receive the attorney bios. There is absolutely no point in copy pasting something that's on the online into the submission unless it's kind of a bit more tailored. So what I tend to tell firms that, if it's a capital markets lawyer who has a very agnostic practice, who does all things for all people, fine, copy it in. If there are specific niches that they're particularly expert in, or if you just wanted to provide a bit more color. So, we might have an unranked, well, take for instance the Cravath example I gave earlier. They might have put in his biography and then just, this person's been awarded American Trial Lawyer of the Year by the American Lawyer for the last couple of years. This is his particular area of expertise. No more than a couple of bullet points if you don't want anything more than that. But then if you are kind of, for M&A and private equity, which aren't, there's less niche expertise there, do feel free just to copy that link in or put it in. In terms of how many,
Mhm.
because there's 20 matters and 30 referees, we've gone back and forth over the years of kind of increasing that number because I've had pushback from the firms and kind of I need to negotiate more people with my CFO if I were to kind of have more matters. But what we suggest at the minute is around 4 or 5 that you're particularly focused on. I know that leads to politics in terms of who you're picking, and I know that's going to lead to some upset attorneys. Unfortunately, if you spread things too thinly, what we like to do is gather kind of a comprehensive picture of an attorney's practice, speak to enough of their referees to know that these people stand out from the rest of the market. I think we only rank 3% of US private practice attorneys. So why do these people stand out? We need a bit of a critical mass of feedback and kind of enough evidence of the kind of work that they do to suggest that yes, these people should be ranked. And that's harder to do if you're kind of submitting 15 people with 20 matters. Conversely, we do receive those same submission template, but just for individual lawyers. If you are literally just submitting one person, you might be working remotely in Colorado whilst you're a Texas-based law firm. Just fill out whatever's relevant. If it literally is just a website bio link, 5 matters that you want to put forward and 10 referees, absolutely fine. It's just you've got to be a bit more selective if you're kind of putting forward a full practice.
Okay. Let's move to the about us, what we like to call the narrative sort of section about the department. What, in your opinion, is the most effective way to use the 500-word section to explain what a department is best known for? Some firms like to include dollar value of matters, maybe talk about some of the chamber's ranked opposing counsel that they're coming up against regularly, maybe talk about some of the highlights that they're going to see throughout the submission for matters. Or can it simply be the same description as the previous year with maybe a few updates?
White collar group, your corporate M&A group is not going to change that much year on year. So if you do want to copy it, feel free. Particularly in those kind of more, not stagnant, but more, areas that don't change every year. In terms, just broad brush, it should be tailored towards your firm. Take, for instance, in the white collar area, if you have a practice that's more bent towards representing individuals, officers, and directors versus big corporates. If you are a private equity firm and 60% of what you're doing is PE in the healthcare space, put that in there. What we like to do is kind of find out what distinguishes that firm against the rest of the market, what are its niche areas of expertise, and what kind of services it provides. It's an introduction to the, so, if your attorneys are rocking up to pitches and 70% of those pitches have been to healthcare firms in the last year, it'd be interesting to know about your healthcare expertise. Nothing too detailed. Again, some firms are going to just copy in the About Us page of the practice group, which just describes your practice as all things to all people. It's designed to do that. That's how you get the clients in the door, by saying you have expertise, which you might not have, but you can get. What we're looking for is kind of that, what distinguishes the firm effectively. In terms of kind of, dollar values of matters, selectively, right? So you will see the dollar value of the matters in the work highlights themselves. We do look through and just, for our M&A rankings, we just look at the average, how many deals at the bulge bracket, how many in the mid market, how many in the lower mid market. So we'll be doing that ourselves in terms of opposing counsel. Again, I think that's in the work highlights themselves where we will be able to see, if your boutique plaintiff litigation firm is going up against Paul Weiss in a big class action, we'll scan through the work highlights to determine that. I think the main thing is, if, for instance, you are a 5-person boutique and you've won kind of multi-billion dollars False Claims Act recoveries, then yes, put the dollar value of the matters in there. It just shows that something that's striking, that's distinguishing about your law firm, as opposed to I'm Davis Polk and I've done however many hundred of billions of dollars of kind of bank side credit deals. That's we expect it effectively with Davis Polk.
Okay, great. Another section that we get a lot of questions about is the feedback on other firms section. I know it's, usually marked as optional, but we did kind of want to, check in on this. Like, how does the feedback section help a department's ranking, if at all? Is it mostly there to just inform the researchers, or does it help demonstrate the firm's knowledge of the industry and the particular practice area that they're submitting for?
Or was in the past, feedback on other firms and our coverage in this area. So I think I would focus more on the latter part of that. If so, I did research this year into corporate governance, and that came out because I looked at a few securities regulation submissions and a few M&A submissions and a few shareholder activism submissions. And a few of them pointed out that yes, we do this work, but we have a distinct standalone practice that just does corporate governance, does the SEC reporting, does the corporate bylaws and the board evaluations, and all the way into crisis management. If you're firing your CEO, if you're disputing Elon Musk's pay packet, you go to a corporate governance lawyer to advise you through it. And because law firms had pointed that out in the kind of feedback on the coverage, they said that our coverage was tilted too far towards one side. I looked into that, and then we brought about this new area of coverage based almost entirely on that, and I think a couple of firms suggested it as well. If there are kind of areas that also, if there's something that we're getting egregiously wrong, like take the False Claims Act coverage. If I know that 90% of the enforcement work in there is healthcare, but if there is a big cybersecurity or kind of defense contracting, if there's a trend that means that more of the big practices are doing that kind of work, and that means that we are significantly underserving your firm, let us know there. Another one that we did this year for the first time was trade secrets, and that came out of our IP rankings. We've been told that we focus on patent litigation and copyright litigation, but the next big wave of IP litigation is going to be trade secrets work, which isn't just labor and employment. It's Chinese nationals allegedly stealing confidential defense technology, right? It came out of that kind of coverage, that coverage area. We don't really use it to demonstrate the firm's knowledge of the industry and practice area. It's also an opportunity just to provide feedback if we've got something kind of ridiculous. So say, we've ranked a personal injury law firm in the policyholder defense side, so we've just been bamboozled. We try not to let it happen. There have been a few firms that I've taken out that I think the researcher just didn't understand. But if there's something that we've done that is just downright stupid, put it in there and we'll read that. We do read it religiously, and it's the first thing effectively that I scroll to when I come to doing my research. What does law firm think about how we've covered the market, and how does it approach the market? What is the firm's own niche? And then we go back to the about us and then go through the matters. It just helps us get a better understanding of the firm's kind of thinking effectively.
That's really helpful. Okay, so now we're going to talk a little bit about matters. We get a lot of questions from clients. Can I submit all confidential matters? Can I submit publishable matters that just sort of describe what I'm doing without actually identifying the matter value or the company? So do publishable matters carry more weight in the rankings than confidential ones? And how do you sort of suggest that firms strike the right balance between providing meaningful detail to the researchers, but also protecting client confidentiality?
So, ways in terms of if you're providing information that kind purple background versus the green background, publishable, confidential. If you wanted to provide 20 confidential matters, feel free. I think confidential, if you're trying to say, in the confidential bit, if you're saying that we represented Apple in an SEC investigation into alleged kind of market manipulation and it's confidential, that it we don't kind of differentiate between whether that was in the publishable section or whether that was in the confidential section. In FTC facing antitrust, in white collar crime, in kind of some of our hairier regulatory areas, there are some firms that are just going to provide 20 confidential matters, which is perfectly fine. There's no judgment there. There's no, when we come to the ranking decisions, penalizing a law firm that, give us 20 confidential matters. When it comes to, instead of Apple, we represented a leading technology company in an FCC and SEC investigation into alleged market manipulation. I would probably shy away from that outside of, shy away from using 20 of those matters because what we do is try to verify it. We'll
Mhm.
speak to the clients themselves. When we speak to our referees, if we ask them, what kind of work did law firm do for you? If they say that we don't want to discuss that at all, they're more than welcome to just skip on to the next section. But we do try to just match the two and two. Um, if it's kind of a white collar practice and you're providing 20 matters where it's, a leading pharmaceutical company, a leading defense manufacturer, a leading public company, then it becomes a bit more difficult. It might just take us a bit longer to assess kind of what kind of clients that firm is representing, what kind of work it's doing for those kinds of clients against the rest of the market. Obviously, your guiding principle here is what your clients are telling you you can provide. I mean, I'm sure when you sign on a new client that you're checking off what you can use their names and their work matters for. If there's nothing that you can provide, then you can't do that in the submission. It's fine. We understand that completely. On the flip side, if there are people that are wavering a little bit around confidentiality and want a discussion with me as to kind of how we approach the handling of data, whether that's the attorneys or the clients themselves, do feel free to put them in touch. We have these conversations all the time, and I can usually reassure them that you know that the database is secure and nothing gets out other than the kind of something that's in green, publishable. And on the other side of that as well, if something changes, if you're speaking to a client and they've told you, well, actually, we don't want you to reference our matters at all, let us know as soon as possible. I don't want to be hosting kind of out-of-date information around confidentiality. So what we will effectively just do is delete the submission from our website, ask you for an updated one. So just when we are looking at it straight away, we can see that it's entirely confidential and not discuss it effectively.
Okay, great. Staying on the matters, we do get a lot of questions too about, how many matters should we be submitting? And so are all 20 matter examples required to be submitted to receive a ranking of band 1 or band 2? And then also in the matter section, there's the list of clients that you can submit. And that they ask, is this a new client or existing client? Is there any sort of significance behind that section as well?
So again, for the first one, it kind of depends on the area. So if it's, every law firm and their dog is trying to put together a mid-market private equity practice at the minute, whether that's ranging right from the AmLaw 20 firms through to everyone underneath kind of going to, local and regional firms, everyone's trying to get a slice of that kind of private equity money. If you're telling me that you're a credible alternative to a Kirkland, Ropes, a Simpson, and Goodwin, what we'd like to see is that you have enough of a practice there that means that you're a credible alternative and you have a standalone distinct practice, which is not just a strategic M&A practice, which might do a few deals for a few PE firms every year, but it's a transactional practice, which we're ranking our corporate M&A section as opposed to PE. Smaller areas, confidential areas, like I mentioned before, fine. Like if you can only provide 15 matters because of the confidentiality policy, put that in the kind of the feedback on the coverage of this and just say that confidentiality policy does not allow us to provide, we don't have more clients that we can provide you information on. But particularly for the kind of competitive areas where this is a very dynamic market. You see Kirkland and Latham kind of shooting off. You see the kind of five firms underneath, five, six firms underneath that are trying to compete for that market. You see a Nelson Mullins, you see a Womble Carlyle and a Lewis Roker. You see these kind of super regional firms. The market is kind of becoming a bit more segmented. And if you're trying to say that you're competing with this firm, what we like to see is that you have a credible group, credible practice behind you. That's for the firms themselves. Obviously, do not feel the need to spend 20 matters on each individual unless they are some sort of superhuman lawyer. That'd be interesting to see. But yeah, for the practice groups, we're looking for a critical mass, effectively.
Okay.
In terms of the matter section, I've been debating getting rid of that. What it's useful for is kind of, if we have a PE practice which says it's all things to all people, we look at the list of clients and see that it's all kind of asset managers investing in the infrastructure or kind of energy space. That's useful because it shows us that they have a kind of a specialist area of expertise. I think when we use it, it's to back up our thinking about the law firm. So see if we take Freshfields as a firm which has been expanding in the US a lot. If we see kind of new, that we know in the UK they represent the big FTSE 100 corporates. If we see a list of, big Fortune 500 US headquartered, US listed public companies, and they come out as new, they tell us that, we've won this client in the last year. It shows us that, the conversations we have about their direct growth trajectory aren't a load of bull. Like they are meaningfully showing us that they are kind of getting that market share in the US. So I think it's useful there. Ultimately, if it's a very static area, if we're not judging firms based on whether they have, six new and kind of four existing, it provides a bit of color and context as to what you're telling us about the kind of clients that you're representing. The main bits of the submission, my advice always is, work highlights and then what the about us kind of, there's the two areas to pay the most attention to. And if this slides by the wayside, perfectly fine. Especially if it's kind of a newer area, especially if it's kind of a more like long-standing area.
Got it. All right. We're gonna get a little bit more into the matters. So what about wins versus losses? How do researchers view a major case that, maybe was a really long case and the firm worked really hard, but the firm's client ends up losing? Does that make the department look bad in Chambers's eyes? Does it, or does being trusted to handle such a significant matter still sort of count towards the firm's credibility?
It does. I mean, I look after our Supreme Court stuff. Like just getting an appearance before the Supreme Court is an achievement in of itself. So, 50% of you are going to have your cases kind of, well, it's not going to work out the way you thought it would. It's still, shepherding a case through the trial courts, through the kind of the federal circuit or the state kind of appellate courts, then up to the Supreme Court. Even if you lose 9-0 in the Supreme Court, it's still an achievement. We were one of 100 or so cases that are going to be argued there. It shows that you have a credible Supreme Court practice because clients are sending work to that kind of specific niche more and more. You're not going to your trial lawyer doing your appeal. You're going to a specialist appellate lawyer. Even if you lose, that's a great, well, not a great thing, but it's an indication that you are kind of at the top of the market for that kind of work, and you have a Supreme Court practice. We have M&A deals over recent years under the Biden administration, which fell down on antitrust issues. But if you were selected by a big, strategic to handle a big corporate matter, which might involve antitrust issues in the European Commission, in the CMA in London, with the FTC or the DOJ here in the US, and it all goes, the litigators screw it up for you. You've still done the M&A deal. It's useful information. The ad tech litigation actually took antitrust that Google is going through, where they technically lost in the trial court. I'm thinking on the appeal, they're probably going to win back a bit more than the public expect. But it was Freshfields, Axon, and Paul Weiss on that matter. And yes, Paul Weiss you'd expect to be on a big antitrust matter. Freshfields, I don't think would have been on that matter 5 years ago. Axon, and it shows that they kind of play at the top of that kind of antitrust market. even though they lost, they were a selection of choice for Google to use to do that kind of work, and it's really useful information. It doesn't make it look bad. It's still in other areas, maybe not so. Like give an example. You know, being unable to defeat class certification, kind of a clearly nuts case. That might I wouldn't put that in there. But for those kind of significant matters, even if the M&A deal doesn't go through, if the litigation goes adversely, do feel free to put it in. It happens quite a lot.
Great. We sort of already touched on this in terms of data or metrics, but sort of to expand on it a little bit more, are there certain types of data or metrics that are helpful to include, maybe billing rates, win rates, case wins, and where are the locations for those to be included? Is it in the bio section? Is it in the narrative section? Is it in the matters? Is it all three? If you could just expand a little bit on that for the group, that would be helpful.
So I think all of us have a few applications that we consider credible. I've gotten emails telling that I could be a ranked lawyer somewhere, and I don't have I have an English literature degree. I'd be really happy to have a lawyer ranking. But things like the Law 360 MVPs, the American Lawyer kind of Litigator of the Year, Merger Market, Bloomberg, kind of those league tables, that's useful information. Particularly, we have a qualitative process, and what we're trying to do more and more is have kind of a quantitative have a quantitative source of information, particularly for capital markets, bankruptcy, M&A, kind of private equity. So I check when our corporate M&A rankings for New York come in. We have kind of elite and highly regarded, and I check against the Bloomberg kind of year-end data just to make sure that if there is a firm that's for the last couple of years has had an explosive year, that we are matching that up against the reality of kind of what these firms are working on and not being too conservative. So that information is useful. We do try to find it ourselves, but if the law firm provides it, that's even better. Lots of these things take a lot of negotiation to purchase for us. What I would do is not go too niche. I mean, if you are the top firm for M&A involving the US and Azerbaijan, where the assets are goat farms, that's not useful information. It's just too narrow. Q1 results also, I have one firm providing me Q1 results for this year. The M&A market is incredibly depressed. What I'm looking for is kind of who at the end of the year is flourishing in kind of a market which is struggling at the minute. That's useful information. I would put that in the kind of the about us, Bloomberg said that we had the highest volume for kind of cross-border M&A with kind of the US assets for the financial year 2024. In the attorney buyers, there's kind of individual awards, those kind of significant trial wins and things like that, then just whack it in as a bullet point under the attorney bio. In terms of billing rates, I wouldn't include that at all. I know it's different for every client. Trust me, I hear the complaints. Win rates, kind of case wins, less so, but in our trade secrets research, I won't reveal who's the band one firm, but they gave us information on the number of trade secrets trials handled in the last 3 years, and showed us where their positioning was, where kind of who the other top litigators were in that area, the ones who were actually arguing motions and kind of appearing before the courts. That was really useful information, kind of backed up their case that they should be at the top of the market. For bankruptcy, I do look at the creditor side, kind of deal counts and kind of the value of the bankruptcies. A law firm provided that to us. Very useful information. But something that's a bit more niche, probably wouldn't.
Okay. Okay. Great. Well, we're going to move to referees. Again, we get a lot of questions about referees as well. The most common question, many of our clients have trouble with referee emails getting caught into spam. What are your suggestions for ensuring that all referees receive the notices from the researchers? Can firms, or in our instance, like an agency, connect the referee directly with the researcher? Or what is your best path to sort of alleviate some of the concerns around referees.
So, so for the US this year, we had 229,000 people being uploaded. So what we tried to do is send out those emails in kind of small batches, because if you send them out in large batches, that's what typically trips you up and lands you on. So we do send them out through the day. But what's useful for us is if those clients know that the email is coming. So, when you're asking them to serve as referees, just point out that an email from an @chambers.com domain will be coming through. It's not someone trying to steal your information. It's not, if you're kind of financial services institutions in particular are always kind of a bit hairy around their firewalls and things like that. Like we have had negotiations with a few of the banks just to kind of blanket get through. But we are working with third parties on kind of whitelisting.
Okay.
It's just with the amount of emails that are going through, it sometimes trips up external firewalls for us. In terms of connecting the referee, yes. I mean, if someone says that they've not received anything, but they're expecting to receive it, do feel free to, the researcher's address is on the email, is on the Chamber's research schedule. This person was struggling to get in touch, hasn't heard from you, and the email's apparently gone through. We will just, send another email over Outlook, just cold call them and organize a time that way. Send them a survey link through a different format. What I would just be wary of is that, I do a bit of research every year. I've had multiple instances where I'm sitting looking at a referee email saying I do not want to participate this year, and then 5 minutes later getting an email from the law firm saying this person hasn't received anything. Can you please send it again? That's what sometimes the disconnect between what you're hearing and what we have to do. I can't really go back to them again. I need to give them a bit of time to cool off and just maybe send an email after that and just be like, by the way, because we make assurances to these referees that the law firm doesn't know when
Right.
you've spoken, things like that. So we just need to we play a kind of a delicate balancing act between not, annoying some of the biggest corporates in America and kind of balancing not annoying the biggest law firms in America either. It's sometimes difficult to juggle.
Totally understandable. Okay, so now we're going to turn to the researchers.
Yeah.
Um, so tell us a little about your researchers and their experience. Obviously, you started off as a researcher, which is great to hear. But how much experience do researchers have with law firms and the legal industry, especially, in the US? And how are your researchers trained?
Yeah. So when I started, we were hiring a lot of law grads, but then the American law firms started coming to London, paying £120,000 a year for your starting salaries, and now I can't get them anymore. Typically, they come in with kind of either a paralegal course, a kind of a humanities, a research-based degree, effectively, and we take them out of university or kind of on the second and third job. We train them for, they'll have their internal training process where we explain the basics of, this is the history of US law, you know, this is how the market is segmented. This is, there's lots of big books that I've read, and I have a whole kind of training course designed for kind of people coming in. And then once we feel that they're good enough, we put them on the calls with the clients, and we put them on kind of smaller areas of research at the start. So when I started, because I studied abroad at the University of North Carolina, they put me on North Carolina research. And then I discovered that I really enjoyed looking after our white collar and our litigation stuff. So then I was graduated onto our California coverage. And then I've discovered I really like the regulatory side. So I did international arbitration and our Supreme Court stuff. And now, 10 years later, I still look after that. The researchers that come in through the door are the ones who are on the coal face are doing the front line. But they're basically coming to the comparative decisions. Sitting above them is someone like me, usually someone who's been here for about 5, 6 years. So I have a team of principal research specialists. Alec, who looks after IP, has been here for 8 years. Matthew Court, who looks after M&A, has been here for, I think he joined about 6 months after I did. I have someone who looks after energy, who's been here for 5. The researchers come to it with that shorter term view. This is what I've discovered that's happened over the course of this year. I come back, so if I go back to my California white collar stuff, I come back to it with a long-term view. So, I was doing the calls when the California white collar market was a bunch of boutiques, and then Gibson, Dunn and Latham and Mofo and Cooley. And in the last 5 years, Jenner and Block, Freshfields, Winston and Strawn, Paul Weiss. someone else has opened up out there, and that kind of where they might be, willing to be a bit more radical and make kind of significant moves. I can bring a historical perspective that clients who have historically been a bit more unwilling to shift relationships away from those kind of California law firms and just calm things down a bit. And then for me and James, who's my counterpart based in the UK, we look those kind of big, the areas which see the most clicks on the website, the prestige areas, corporate M&A in New York, white collar crime in kind of New York, California, and our appellate coverage. We'll then take a third look and just make sure that we deal with the firms a lot more regularly. So I was out with last week. I've seen five AmLaw 100 firms, five AmLaw 10 firms, sorry, thinking about kind of leadership changes and long-term strategy, and we can bring that kind of view in. There is a tendency, if you're a researcher, that you're speaking to a 65-year-old expert on this market who's been doing this for 30 years. And if they tell you that, Kirkland is just a litigation shop out of Chicago that's never been a success, you might be tempted to believe them. I've looked at the AmLaw 100 rankings for 10 years. I've spoken to most of the executive committee. I know that firm a bit better, so you can provide that kind of, at my level, that kind of the principal research specialist level, that longer term strategic view as to, this is what the market actually looks like if you've had the wool pulled over your eyes.
Okay, great. So we have some other questions that were submitted by registrants. Or actually, sorry, we're going to go to the post-submission follow-up first. So for researchers, so following the deadline submission date, do researchers accept regular updates about the attorneys in the submission and case developments? Is this type of communication with the researchers encouraged? And do they, will they accept ongoing updates throughout the research period? Does it extend beyond that, or is it really just, within their research time period?
I mean, on the research period, it's kind of a significant update in the case that was on appeal before the Supreme Court, and you've got the opinion through. Fire away. I mean, I would keep that until around February for the researchers themselves. But then if there is, so if you go to the chambers.com, click on the USA, scroll down, that's all of the senior people divided up by their practice areas. If there are significant updates after the research period has ended, I would send it that way. Send it to them, sorry, as kind of the people who oversee. I would limit it for, your biggest matters. I mean, and not for kind of, if it's a 6-year class action or an MDL, you've defeated class litigation for one case, but there's 20 cases outstanding, probably less relevant to kind of fire that off to us. But if there is conclusions, if there's kind of, a big lateral group that's come in, if someone's left the practice, if someone's retired, then do let us know, keep us updated, and we will reflect that in our coverage. I mean, in 10 days' time, Herbert Smith Freehills and Kramer Levin are going to merge. So when I got that update afterwards, trying to work my labyrinthine database to reflect the merger is not fun. So I'm going to be very grumpy for the next few days, but those kinds of updates are really useful.
Okay. Great. Okay, so now we're going to move on to the other questions that some of the webinar registrants submitted that maybe didn't have to do with the actual submission or the methodology, but some other, items from chambers. So one question we got was, why isn't there an appeal process for firms that think their departments or lawyers have been misranked or not been ranked at all? And there was a question that came into the Q&A that kind of relates to this. It's saying that this question had to go back to the attorney ranking slide. Are you saying you'd engage in discussions with firms to update a lawyer ranking after the rankings come out, or do they need to wait a year for that sort of proper adjustment?
Yeah, so when I started at Chambers until about 5 years ago, there wasn't a appeal. We told every law firm that you could send us 7 questions on attorney rankings, and we will kind of get back in touch with you and kind of explain that in more detail. What it quickly turned into was 7 per practice area or 7 per kind of different office, and I'm already dealing with. I'm looking at my inbox and crying, but it's a lot at the minute, so we've had to kind of narrow that down a little bit. I think if there's something that's particularly egregious, get in touch with us and we will do as best as we can to do it. But I would limit it because if you tell the attorneys that, obviously everyone is going to get in touch with you and try to appeal their ranking. I'm sitting on one from a law firm of 20 and I don't know how I'm going to respond to that. If it is something that's, very obviously an error, then get in touch. Very often, we did this last year, and I pulled the stats on how many changes that we actually did post queries, and it was kind of less than 1%. I'm relatively confident in my research team. Very often it's, we haven't got enough referee feedback. The work isn't entirely relevant or it's not comparable to who's currently there, or we might be just looking at a kind of a longer term view. So it's particularly in some of the more, California corporate or technology, New York corporate. It just we might want to kind of, we've built a bit of a foundation, but we want to build on that. So yes, if it's, you've hired the US attorney out of, your local US attorney's office, they've done their 1 year of kind of non-compete against the DOJ. They've done 6 or 7 big cases and we've not looked at them. Get in touch. We will take a second look. It might be the case that we've just not heard enough about their transition back to private practice. But we can't provide too much detail because, we're not going to go into a lot of information as to why this attorney isn't ranked and go entirely through our rank decisions. I mean, ultimately Chambers has to make money, and that's part of the product offering that you'll have to deal with your salesperson for. We have to kind of divide between the commercial and the corporate, commercial and the research team here at Chambers, but we can't go into like oodles of detail into every decision. And bear in mind, there are about 1,000 firms that are ranked in the USA. So if everyone gets in touch with me to appeal one decision, that's my job for a year. So I would use your judgment. If it's particularly egregious, then get in touch with us and we'll take a second look, but I can't promise that we will make a change. I'm very often I feel like it's justified.
Okay. So not to make your inbox any more sad, but when you do say get in touch, is that should firms be reaching out to you directly? Should they be reaching out to the particular researcher that maybe researched that section? Or is there, I know you mentioned that other page where you can see where everyone oversees certain areas. So is it more appropriate to kind of view that page and make a determination based on that, on who to contact?
People give you so when once we get around to answering the Q&A questions, I'll send a link with that. It's basically on the Chambers USA homepage. We're all on that, but send to the people who oversee practice areas as opposed to the researchers themselves.
Okay. Okay, next question, and you sort of already went into this, but there's often the perception, especially among some smaller firms or those maybe newer to the Chambers process, that Chambers rankings can be influenced by marketing budget or PR resources. We do hear this concern, particularly from, maybe firms that lack the internal support of a marketing team.
Yes.
So how do you respond to these concerns that the rankings process can feel overly driven by marketing resources rather than just by legal merit? And then given the high cost of participating in the rankings process, I think what this is referring to is really, purchasing the profile platform or purchasing some of those insights reports. How does Chambers ensure that smaller, less resource firms still have a fair opportunity to be recognized?
Yeah, I mean, some individuals that are ranked without a submission. I would take issue with the idea that I'm ranking some firms in band 1 and band 2 because they've got a PR budget to spend as opposed to conversations that we've had with their clients and kind of the other market participants, or feedback that we've delivered to drive based on this firm has come up in a submission as opposing Paul Weiss in a matter, so I'm going to do a bit of digging and kind of find out. We've got this year, I think there's about 50 new plaintiff firms that we've ranked for the first time, and that's purely through, they have a marketing budget for the size of billboards and the size of buses and stuff like that, but they don't spend anything on Chambers. But it's based entirely upon us kind of looking at filings on briefs, doing kind of calls with the repeat players and kind of big commercial litigation matters and product liability matters, and saying, who do you come across that's credible, that's not an ambulance chaser? And that's kind of what's led to that ranking. And they probably won't submit next year because they'll have to take a bit more, we'll need to get them on board with the process for a bit longer. but we're still going to rank them if they're good enough. I mean, it's not based. I think it depends on how law firms use, if they want to use the submission process as, oh my God, this is Chambers, I can understand that. But it's also, I've heard from some firms that use it as the knowledge management kind of the singular resource, you use that. Don't tell them I said this, but I know that Legal 500 and IFLR and that will accept our submissions, so just fire off that off to them. But also if you want to use it for kind of, end of year press, review of the kind of work that you've done that you're sending out to your clients, sending out for your press releases. Lots of the big firms use the Chambers resource, as a Chambers submission kind of template as just something to work off of the year. And if you want to just, you know, sending your submission in July of this year, on August, just have an Excel spreadsheet and just, these are the matters that we've advised on. This is something you might make as a Chambers submission. It doesn't need to be kind of an overly laborious process, especially if it's kind of a small, for New York corporate, it's going to take a bit longer, but for something that's, a bit more straightforward, we don't need the whole hog, effectively. In terms of, making sure less resource firms have a fair opportunity, we have an entire submissions team here at Chambers. We'll put the contact details in the kind of the follow up, who kind of help firms along the process. Every year when I do the schedule anew, I update all the kind of the guidance on how to submit, kind of it's all up on the website. We do things like this. I'm doing another one tomorrow. There's apparently one going on at the same time, which has fewer attendees than this one. So congratulations on joining this one. To kind of help firms through the process. And then, do feel free to get in contact. This time of the year is a bit iffy for us, but through the course of the year, we're happy to just jump on a call and just talk about, these are the best types of referees. These are the best types of matters. This is what we're looking for in our artificial intelligence table. It's our regulatory, it's transactional, it's commercial. And in the future, we might split it off into all three. But if you want us to explain that, and we don't want to be a black box in London and kind of here in Rockefeller Center in New York. We want to be able to answer those questions as and when they come up.
Okay, great. So we only have a few minutes left. I do know we have 10 questions that came in. So I think what we'll do with those questions is I will share those with Kush after the call today, and we'll get responses for you, and we'll send those along with the replay next week. But I think the final question, Kush, that I just wanted to ask you is, what is one thing you wish firms understood better about Chambers?
Get in touch. I mean, like I like having conversations. I'm British. I go to the pub a lot. If you want to join me, come along. But if I was at a few firms today, I was meeting a couple of CMOs of big law firms, and they seem a bit worried about bringing up meeting with lawyers. I mean, I'm always happy to meet with senior lawyers and explain the process. I'm always happy to speak to law firms to see how they're, I'm glad I'm outside the legal market rather than inside it. But speaking to people about how they're seeing things going, what the strategy of their law firm is, I love those conversations. We don't want to be kind of a closed box, like I said. Like we have, what was it, 29 people here in New York? But when I started, it was 2 people in like a prison cell in Midtown Manhattan. And now we've moved to our flashy new offices in the Rockefeller Center. But if you wanted to speak to, your salesperson just get an update, come along. If you want to speak to customer success, kind of talk a bit about, what your submissions and kind of what you're doing with Chambers, come along, have a chat. I know lots of law firms pass through London. I'm on the road a lot. If you have a question, fire off an email. We're not going to kind of bite you for doing it. It's we do want to be, we're here to meet people and be open and do things like this. So don't be scared of getting in touch effectively.
Amazing. Well, thank you again to everyone who joined us today. And obviously, a huge thank you to Kush for his time and for answering all these questions. It really helps to demystify the process and give firms the insight they need to strengthen their submission. So we really appreciate your time. If you do have additional questions, as I mentioned, we have 10 questions I see in the Q&A right now, or would like to connect with us for any reason, you can email me. My email is right up here. As I mentioned, a recording of the webinar along with the responses in the Q&A will be shared next week. Before we go, we do want to invite you to join us for our next Post and Playbook webinar on Tuesday, June 17th. We're going to be talking about share a voice, leveraging knowledge, data, and analytics to build an effective communication strategy and drive revenue. The speakers for that will be our CEO, Dave Poston, and our Vice President, Andrea Chrisman. In this session, we'll show you how to unite your business development and communication efforts through integrated monthly reports. We'll walk through our proprietary model that blends financial analysis, client teams, market trends, AI tools, and more. And then we'll sort of dive into how to run productive strategy meetings that keep your efforts focused and adaptive. So ultimately, you'll learn how to connect client needs with current opportunities to increase engagement and accelerate growth. So those email registration should open here shortly. So hopefully you all we'll see you all in June. So thanks again to everyone for joining us. Kush, thank you so much. And we hope to see everyone next month.
Thank you very much.
Bye.